1.01.
We have heard that the plaintiff is entitled to amount of rupees 62 lakhs in full and final satisfaction. The amounts deposited to be withdrawn.
One 502.
The judgment of the High Court and the tribunal, they are set aside. Appellant is held entitled to notional promotion in the HAG grade and to receive all pensionary benefits.
Eight zero one.
Very clear.
What is the urgency, sir? In this?
Generally, I expected that be perfect.
My lords, even otherwise, the matter is referred for mediation.
Despite my best
trial.
effort, my lord.
That will come in August. Sir.
My lord,
State may be given so that my lord, at least the matter.
My lords, it's coming in August for the mediation drive under Samadhan Samaro. So
That is all.
that definitely, yeah, absolutely,
Go for resolution.
absolutely, my lord.
Always.
Any date might be fixed then, my lord.
It is coming in the local date probably August 20th to 21, 22.
My lords, 21 to 23rd of August. Please,
Come in there.
Grateful.
Grateful, my lord.
802.
Lordship, this is the case.
What is the urgency, sir, in this one?
The denial of the maintenance from the last 12 years. Your Lordship, I had a
You can do, sir.
child. Your
Wait
Lordship.
for some time more. In 2 days, nothing is going to happen. Is not going to fall in 2 days. Since you are doing 12 years. August.
803.
My lord, I'm sorry.
803, this is a service matter. Milord, your lordship has stated the matter. Milord, I have joined the service, but they have not objected it for me for Milord, yes, we have filed an interim application. Milord, it's been filed on 19th of March 2026. Milord, IA number 873.
Why you have not requested earlier?
Milord, the matter was supposed to come last week, but it was not taken up. It was showing today, Milord, but however the matter is not shown up today in the cause list. Milord.
Possible that will come either
Well-
to ask for during vacation or.
My lord, it can
Well,
be
it's any-
recorded after partial working days.
Milord,
That is,
let my
Pretty
interim
okay.
application be decided. Milord, what has happened is, Milord, your lordship has stayed the order. Then we have joined the service. They have not objected to it. But we have requested for the salary. They say that the matter is pending before your lordship. Until unless that's decided, they will not release the salary.
They have joined by that.
they have
time.
joined, but they are not working anything.
Milord, they
just
have not
come
objected to it.
attendance rate and they're going.
You are not taking work, then what we can do? If they are putting an attendance is there, then.
But
how
they are
you
not
can make
working.
functioning?
Milord,
My lord, they are
work,
not doing.
Please, wait. We can thought of it passing on some order. Yes.
My lord, they are not doing anything. They just coming just for the sake of the attendance.
In your office, sir, you will assign a work. They will take a work once they are joined.
My lord, I just need like after partial working, after reopening the court, I'll request a date for this thing.
Milord,
Take a application has been filed for non-payment of the salary. Police counsel for the respondent summons. Like the petitioner, huh?
yes, Milord.
but he is not working. However, the to take working, those signing on the register. Full stop. The respondent has to take work from them and make a payment of the salary for the working period.
Oblige, Milord.
804.
804. 804. It is only an application for deep tagging, no urgency.
My lords, there's a mentioning, my lords, the council is appearing through VC, my lords, Mr. Karthik.
Your lordships, actually, there's a only a small mentioning, your lordships, on this point, that on 26 November, your lordships passed a judgment in my favor. I was pensioners in Himachal Pradesh. Then, your lordships, I filed a contempt in Himachal Pradesh, and there an order was passed that in January for compliance. Then, your lordships, in April, they say that state of Himachal Pradesh says that we'll file a review petition. Now, your lordships, when the matter is listed today before the Himachal Pradesh for compliance of that judgment, which was passed by your lordships on 26 November, they have yesterday filed a review petition, your lordships. One of the persons has already died. All our pensioners, your lordships, all I am requesting is my colleague is carrying the copy of the review, the status of the review petition. That review petition may be listed whenever your lordships deem it fit. They have intentionally delayed it from 26 November till now date, your lordships. Till 26 May, they have not filed the review petition.
The procedure for listing of the review is, if it is not a miscellaneous day, we would have taken it up. Once it's a miscellaneous, then we have to assign a reason why I am taking up this review. So this is a procedure. Why we should do for this?
I bow down, your lordships. Out of the 4 respondents, 1 respondent is actually expired in April, and your lordships, all of them are 80 years and up.
My lords, may I make another unlisted mentioning, my lords? This is for listing of a miscellaneous application arising out of order passed by my lords. My lords, the defects have been cured. My lords may kindly direct that it. My lords, all the defects have been cured in the app.
You are asking for.
My lords, listing of the miscellaneous application, my lord.
Nothing. Next.
My lords, may I please request for mentioning of a contempt petition, my lords. A status quo order passed by this honorable court has been violated. It's a fresh.
When the case is coming. When the case is coming.
The main case, my lords, the parties are before the mediation center, my lords.
What we can do, ma'am, please tell us what we can do.
My lords, the status quo order passed by, during the mediation proceedings, my lords, the status quo order has been passed by this honorable court.
So,
and that order is being violated by the
violated, you can file an application, court will look into the violation.
My lords, we are filing the contempt petition, my lords.
File it, then we'll consider.
My lords, we kindly allow for urgent
No,
listing, my lords.
Do so. Yes, please.
May I have your lordship's indulgence, my lord, to mention a IA in, my lord, that UP teachers matter. In UP teachers matter, my lord, on 13th, your lordship directed that the merit list is to be prepared of all the candidates. My lord, there is a clarification required. That means all the teachers who are on the list, including in the 0 district. My lord, they are saying that in the 0 district, they will only give the district merit list and not of all the candidates. So that clarification is required. I have moved an application. I have informed all the councils tomorrow. I am grateful.
Take it tomorrow to everyone you communicate.
I am grateful.
Wait, please.
May I point out in this, my lords, Mr. Khanna's matter, my lords. Basically, my lords, will answer it tomorrow, but 30 seconds. Basically, my lords, your lordships has passed 3 orders, and this application is in fact a review of all those 3 orders.
We'll see tomorrow.
Yes, great.
Yes, my lord. I am appealing for the respondent, my lord. We have filed a counter. My lord, the matter pertaining to the cancellation of bail, my lord. The section involved in this case is 132 of GST Act, which is trial by the magistrate and, my lord, the punishable for the terms of 3 years and up to extended up to 5 years, my lord.
Let us understand. With all fairness, are you a accused person?
Yes, my lord.
With all fairness, are you ready to offer the amount which is of defalcated 50% minimum?
My matter is still under the investigation, my lord.
Anything else?
The entire allegation is incorrect, my lord. The total revenue is 11 crore, and
this is not a case. This is not a case of grant of anticipatory bail. Until you offer.
My lord, kindly see, my lord, kindly see the para 4 of the order, my lord. Kindly see the para 4 of the impugned order, page 3, my lord. It says that merely by issuing a notice under section 30 of the GST Act does not make a person accused, so anticipatory bail is not maintainable in this case. On the other hand, my lord, the DGGI has arrested me in another case related to section 70, my lord. I am in judicial connected case. If the petitioner wants to interrogate me in custody, they can interrogate me.
Also be satisfied then. We are aware of the fact.
Yes, my lord.
Well, in fact, the inquiry that is going on is
And,
under section
and
17.
admittedly, we have joined the investigation, my lord. They have admitted in
You are
the,
already in custody.
yes, my lord.
May come in custody of this, let them interrogate in this.
So they may interrogate, my lord. So cancelling the earlier bail is not required, my lord, in this case. This is my humble submission, my lord.
Okay. Anything else?
No, my lord.
After hearing the counsel for the party to play, ऊपर लिखते हैं arising out of the bench answer irreversible refund the defalcation of 11 crore 8 lakhs 79,628 is involved in this case by your the respondent is already in custody in another case.
Yes.
After hearing and considering the facts and circumstances of this case, in our view, the clear square for the reasons I stated in the order is not justified. Accordingly, the order granting anticipatory bail steps satisfied. Full stop. Petitioner may also be, respondent may also be taken into custody in this case. And custodial interrogation as contended to find out the truth may be made. Full stop. With the aforesaid observation. Full stop. We make it clear that rejection of the setting aside of the order of anticipatory bail will not come in the way in case the petitioner applies for grant of asylum.
Wait a minute.
Respondent applies for grant.
Yes. Wait a minute.
May it please, my lords. My lords, as per the last order, my lords had asked them to file the CDR, my lords. We have seen that. Please have a look at 3-4 pages, my lords.
If I can explain the CDR, my lord, it's my affidavit. If I'm permitted to explain the CDR, my lord.
Very well,
Let her explain.
very well, my lords.
My lords has that affidavit, my lords, filed by the state, my lords.
Yeah, my lords.
It says counter affidavit.
You are referring counter, no?
Well, it's a heading is counter, my lords.
There are 2 counters filed by them. The one filed on 23rd of May, probably she is referring to, my lord.
The time of incidence is, ma'am?
My lords, roughly around, my lords,
240.
my lords.
Sir, Mashiji, you are very
Very well, my lord.
to harp upon for everything. Let Madam may say something.
Yes.
She is stating that I have filed the CDR. So I
Very
am going to explain.
Very well.
Let them explain, sir.
Well, it's roughly around 2:30 to 2:45 is the time, my lords. My lords, may just kindly come to page 18, my lords. So this is the CDR of the petitioner, my lords. We have filed the CDRs of 3 persons, my lord. The petitioner, the driver, Rupesh Kumar. My lords, we have filed the CDR of 3 persons, the petitioner, the driver, Rupesh Kumar, who is the co-accused, and my lords, one Vishal, who was piloting the car of the co-accused, my lords. So this is the CDR of the petitioner, my lords. My lords, we have highlighted in blue mark, my lords. Page 18 towards the last 3, my lords. Last 3 rows, my lords. This number, my lords, which ends at 876 is of Vishal, my lords, who was piloting the car of the co-accused, who had hit the vehicle of the police, my lords. My lords, may kindly see the timing, my lords. My lords, 2:19:50, then 2:20,
2:25:4
and 2:27:14.
14.
Please, my lords. My lords, the timing is also, my lords, 26 seconds, 29 seconds, 69 seconds, my lords. My lords, may then come to, my lords, the...
Simultaneously,
Please.
what is the statement has come for that effect? Kindly that may be looked into.
Please, my lords.
What is that statement?
Statement is that he was on a conference call with the petitioner.
Call
With the petitioner.
while the offense was being committed.
Please, my lords. I bow down, my lords.
commission of the offence is 245.
Well, it's roughly around, my lords, 230 to
Roughly
241.
around, madam, when we go for any of the offence, commission of the offence, then we have to look into what is the time.
Please, my
And
lords.
time is an essence of some time.
Please, my
Otherwise,
lords.
on the basis of the set timings,
Please,
you know the acquittal may go on.
please, my lords.
So now here it is a case, if it is a case that prior to that he receiving the instructions, he did this offence.
Please.
Fine.
I'll try to satisfy, my lords. I'll try to satisfy. My lords. Yeah, my lords. Now, my lords may come to the co-accused Rupesh Kumar CDR, my lords. Page 43, my lords.
43.
What I am trying to establish, my lords, is that there was a conference call between three persons, my lord. The petitioner, the co-accused. Please, my lord.
We can understand that it's a conference call.
My lords, I'll just show, my lords, how.
Call is one to another, one. Conference with three.
Please.
How it will
The
be
time will be overlapping, my lords. The time of the call has to be overlapping. There cannot be two calls.
reflection.
I'll just try to say.
understand
Please, my lord. I'll just try to explain, my lords. I'll just try to.
It's tell us.
Please, my lord.
Suppose a person is talking on a conference, 3 call, 4 call.
Please, my lord.
So how it can be reflected in a CD?
My lord,
The
the,
CDR which you have
please,
filed.
my lord, the time is overlapping, my lords.
Means if A is talking with B
Please, my
and B is talking with A, so timing of both mobile numbers would be overlapping.
Please, my lords.
So it would not be the conference call with A, B and C. Because if you look into the timings of the C mobile,
Please.
that appears to be 1 minute prior.
Please, my lords.
Fine.
Please, my
So
lords.
meaning thereby, if A will talk to B, then on the CDR of A, same time would come. If B is talking with A, in the CDR of B, the same time would come. So that talking of A and B would of the same time would not be any objectionable, because it is on the same time. So one is talking to another. So we'll take a CDR of one, it will come same time. If you take CDR of another, it will come on the same time. So it would not be a conference call. It may be a talk with A and B.
My lords, what appears, my lords, prima facie, what appears is that the petitioner had called Vishal, who was piloting the car, my lords. And thereafter,
Vishal's mobile number is which?
my lords, I'll just, it's at page 63, my lords.
63.
My lords, please, my lords.
876.
Please, my lords. 876 is Vishal's phone number, my lords.
All right.
So, my lords, page
One
63,
minute. Suppose from this, how we will understand by this chart,
please.
who called? Vishal
lords,
called or this man called to Vishal?
I will just, my lords, page 63, my lords. My lords, page 63, if you see, my lords, the blue highlighted, my lords. 6th and 7th row, my lords. 6th and 7th row of page 63, my lords. So 876, incoming calls. My lords, miss, kindly see in. It's in.
Page number 63.
Please, my lords.
In means where?
Incoming.
Oh.
In and out, my lords.
In and out.
Please, my lords. So 876, incoming call, 6667. That is of the petitioner,
Yes.
which we also find from the petitioner's CDR.
Yes.
So he called for 69 seconds. Immediately thereafter, my lords, may kindly see 876 again calls Rupesh Kumar 1991, and which lasted for 1412 seconds, which roughly comes to around 23 minutes.
Yes.
So both the calls were made by Vishal, my lords,
Yes.
to the petitioner and to the co-accused, my lords. And the connecting call was made by Vishal to both the persons. My lords, may kindly see 227 14 69. They have filed a discharge applications, and my lords, that is listed, which is coming up on 28th of this month, my lords. My lords, had the gravity of the offense not been such, my lords, I would not have tried, my lords. My lords, there's
Question, you are a government.
my lord, that is why, my lords,
We have to assess.
please, my lords.
They have
My
to
lords,
defend.
it is not
Fine,
one.
And we have to decide.
Please, my lords, please.
That is all.
I would.
Nothing more.
I would.
We should not gravity and you know, this is like this. This
And the-
hardly makes any difference, madam ji,
Please, my lords.
to us.
But there are 4 other FIRs where both these persons are common, same offense, prohibition, my lords. My lords, against the petitioner, so many offenses are there, my lords. He is a hardened criminal, my lords.
Yes, sir.
May it please, my lords. My lords, 2 submissions. Please have a look at the first counter affidavit filed by them at page 2. Incident happened after 2:45. May I kindly note. Please have a look at the first counter affidavit filed by them.
On dated, first counter is dated
My lord, that is on 12th of May 26.
12th of.
May 26.
Yes, sir.
My lords, may I have page 2 of that.
Yes.
So I want to show the time of the incident. Based on the said secret information, the police authorities had, and before that, I just want to place one information. Vishal is neither an accused nor a witness. This is very
He
important.
is in a separate FIR against prohibition, my lords.
In prohibition, but not in. Yes.
Yes.
Based on the secret information,
What do you want to say of this?
so my lord, the incident happened after 2:45. They themselves saying in the counter. Now please see charge sheet also at page 56
56 in your.
in the SLP paper book.
Yes. Understand, it is of fine. It is of.
So what they say is that was coming from Kharbat, Country Liquor, Ahmedabad City on dated and around 2:45. Right, my lords? So incident happened after 2:45. Now please see the chart filed by them. Page 4 is my phone number, which ends with 667.
Filed by them in counter affidavit.
Yes. And Rupesh's phone number is 1991, my lords. Now
Page
please.
number 4.
Yes, so this is just want to show the phone numbers, my lords. This, my lords, have already been told to. So my phone number ends with 67. Rupesh's is 991. Now at page 17.
667 is of yours.
My phone number is 667, yes.
All right.
And Rupesh's is 1991 in the end. Now
Yes.
please come to page 17
Where
of
is
this.
that 1991?
My lord, that my lords would find at page 36 Rupesh's phone number.
Page 36.
6. And my phone number as per their chart is at page 4.
Page 36.
Yes.
Number of so and so 991.
Yes. My lords have seen that? It says
There is
Rupesh.
Name mentioned.
My lords may say it's a 5-6 column, not Rupesh Ramesh Bhai. And at the top, my lords, is the phone number.
Yes, fine.
Yes. And at page 4 is similarly, my phone number is there if my lords want to have a look.
Yes, sir.
Yes. Now please come to page 17. I spoke to Rupesh last at 1:31. Please see page 17. And this was noted by the High Court at page 70 also. Please see at page 17. My phone number would be this one. My phone number is at the left with the answer 667 at serial number 1, 2, 3, 4, 5, number 7. I spoke at around 110, then at 131 and 131. And they themselves say in their counter affidavit and the charge sheet, the incident happened after 2:45. So I could not presume that after 1 hour, someone will stop the car. And before that, and 1 hour before, I had told them, you please crush someone.
Let us understand. Who was the person found on spot? Rupesh.
Rupesh.
And Vishal.
And Vishal is not an accused in this matter. Neither a witness. Please see the charge sheet. Who are the accused and the witness?
is not an
Not an
accused.
accused, nor a witness. And they are harping on Vishal. So my submission is, please see page 49 charge sheet. Who are the accused in this matter?
Page 49.
Yes. Number 1 is Rupesh Kumar. And I am at page 53. Number 2.
Page number 49.
My lords, yes, page 49, my lords would find this chart over the page. My lords may say accused Rupesh Kumar at page 50.
Rupesh.
Yes, now please come to 53. That is me, Bhupendra. So there are only 2 accused. And I spoke to
Not a witness.
and he is neither a witness, Vishal, strangely. And now, my lords, the stage in this matter, my lords. So I last spoke to him at 1:31, incident as per charge sheet and as per their own counter after 2:45. So I could not presume that someone will stop a car and I would have given instruction to crush someone. And please,
Vishal is not an accused in this case.
no, Vishal is not an accused. Now
Vishal
this
is not an accused.
Vishal
Not-
is not an accused.
Not in this case, because the charges, my lords, it's 302, 307, 333. My lords, quad the Prohibition Act, there is another FIR lodged, my lords, wherein he is accused for the same, on the same date, same incident. So
Now-
because, my lords, the car, he was acting at the behest of the petitioner, my lords.
He should be. Okay. Okay, after approval of the record and the CDR. Learned counsel for the petition on the basis of the evidence. Learned senior counsel for the petition on the basis of the CDR substance. And the story as brought in by the prosecution regarding commission of the offence by the accused while the petitioner was on conference call cannot be correlated with the CDR details. Full stop. Since the timing is not matching. Full stop. On the other hand, when it comes to the state, seriously opposing the words, talking time with the accused with Vishal appears to be of 10-15 minutes prior of commission of the offence. Therefore, the possibility of commission of the offence cannot be ruled out. Please do. after reading the concept of the parties, we find that the Vishal is not an accused in this case. However, the relevance of the CDR, if any, may be looked into, established by prosecution during trial. At this stage, petitioner has already served, already in custody since last more than 2 years and 3 months.
Yes.
And the application for discharge filed by him is pending. However, without expressing any opinion in light of the case, we give it appropriate to release the petitioner.
So grateful, Manoj.
Obliged, Manoj.
Lordships, in item 3.1, I seek for a short accommodation. The AOR is down with high-grade fever. Just for today, if we can be accommodated. 3.1, the tag matter.
They were taken up together. My lord, if it can,
They were taken up
Friday,
together,
my
Your
lord, because
Lordship.
our counter is also ready, my lord.
My lord, can I just say this? Please.
Tested
No, but please just.
We are ready to assist.
My lord, on Thursday when this matter came up, learned ASD said a counter is being filed. We waited for it till yesterday and today it's not come. If he gives it to me today, your lordship may take it up tomorrow. I am willing to do it today. I am not asking for a date today also, my lord, in item 3. So let him give it to me today.
3.1, just
Tomorrow you can come. My lord, she'll come tomorrow. My lord, please, this is a bail matter. Your lordship may have it tomorrow.
Please.
Not tomorrow,
Your
my lord,
lordship.
Friday, my lord.
My lord,
Friday, I cannot list.
yeah, tomorrow please have it, my lord.
My
I
lord,
cannot list for Friday.
I am going to see my father, my lord, but not today, my lords. I have some difficulty.
Vacation.
Lordships.
My
Yes,
lord,
Please.
yes, my lord. Let it come. Let him come.
my lord,
Or, my lord, it is such a case, my lord, that it can come even after vacation.
no, my lord.
Because the
My
person, my lord,
application, my lord.
now, my lord, they are
My
playing
lord.
with the society, my lord, in the cover of license.
So my
They are
learned friend,
playing with the life of thousands of persons in the society,
so
my
my
lord.
learned friend does not
The
want me
such
to argue
person
the
and
matter.
holding,
I
he has,
should be
and the
rejected.
custody is only 1 year, my lords. The persons who are selling such drugs, my lord.
Let it come during vacation.
Lordships.
No, let it come during vacation. No, Mr. President. Counter affidavit is not being filed. It be placed on record.
I am willing.
And placed on record.
After 15th, my lord.
But in both
And
cases.
any day after 15th, my lord.
No,
No,
sir.
my lord, let
Then
me-
in the sec.
No, sir. Next week.
Yes, my lord, next week.
Please tell
All
me,
right.
first week of vacation.
Problem.
You go and argue, sir.
All right.
Whatever would be the fate, we don't know.
That's right.
It's a bail petition, sir.
Correct.
And which cases will be listed?
But-
Bail will not be stayed.
No,
Vacation.
I'm not that. But bail of a person, my lord, who is playing with the life of thousands of
Go and
people in the
oppose there.
country, my lord, in the society.
Go and oppose, no problem.
Ah. Great.
Please, Your Honor.
Yes, sir.
Yes, my lord. My lordship, on the last date of hearing, my lordship directed to verify the charge sheet has been filed under section 394 or not, my lord. My lord, charge sheet has been filed under section 397. If my lordship may kindly see my counter affidavit, my lord.
What is the allegation? We have seen your counter affidavit, particular para 15.
Yes, my lord. We have.
Anything else? Fine. Now let us understand.
Yes,
What is the deadly weapon recovered from him?
Yes, my lord. 397. My lord,
Sir, please, what is the deadly weapon recovered from him?
the motorcycle was recovered, my lord. The motorcycle, my lord.
So how it can be a case of 397? There, IPC. See the language of 397.
Yes, my lord. May I read, my lord? 397.
Yes, sir.
If at the time of committing robbery or dacoity, the offender uses any deadly weapon or causes grievous hurt.
So what is the deadly weapon recovered and causes a grievous hurt? Please tell us two things.
My lord, it's or causes grievous hurt. They had been, my lord, assaulted, my lord. They had been assaulted. If my lords may kindly see the FIR for a minute, my lord.
What is the grievous hurt, sir?
Yes, ma'am.
Anything else you want to say? Please tell us.
No, my lord.
Otherwise, we are granting bail.
Very well.
Okay. After hearing, do you want to say? After hearing, let me come for the company. And on provision of the allegations. The recovery only of motorcycle. From it. So we created a custody. Which is about 2 years.
2 years.
And the trial may take time to conclude.
Less than 2 years, my lord. 1 year, 10 months, my lord.
1 year, 10 months. And the first side as reflected. Or without expressing.
Obliged. Obliged, my lord.
Item 6.
My lords, Mr. Hegde is appearing on BC Minds.
Please, my lords. The main conspirator in the criminal case, my lords, has been granted anticipatory bail on the ground that his name does not figure in the FIR. FIR was against unknown persons. It was a very ghastly attempt to murder in the open city, my lords, by unknown persons. FIR was registered. The unknown persons were arrested. Then it was revealed, my lord, this petitioner, through his gunman, hired those unknown persons. Within, my lord, 2 weeks, my lord, interim anticipatory bail is granted on the ground that he was ill, though he was not.
It is a financial trail by this man with the gunman.
No, his gunman, he uses his gunman, has gundas from, my lords, UP, Goa, etc. to eliminate his political rival, my lords. And it comes to light in the course of investigation.
Learned counsel, what we are asking is, if
Please.
his gunman do have some connection and payment by the gunman.
Through the gunman. So I should say it's through the gunman.
You can say, sir, please listen. Once a minute, senior counsel.
Please.
Is it any connection that this payment has been repaid by this man, reimbursed by this man?
Please, my lords, there were 2 police constables along with my lords, this petitioner. They have given the statement about the conspiracy. And statements have been recorded, certain statements have been recorded before the magistrate. They have spoken about the conspiracy, my lord.
If
Please.
you are this way, we will not accept any contention.
Please, my lords.
The region of his political enemy between not there. And now the situation is coming is allegation which is coming, the man was murdered and this one gunman having a connection with the persons who committed an offense made a payment. Now you are connecting through gunman to this man. So we are asking in this situation that payment, whatever is made by the gunman, have you connected that this payment has been repaid or reimbursed by this man?
Please, may I answer like this, my lords? Investigation is at law. Investigation is pending. Still at the stage of investigation, my lords. And my lord, that gunman is not yet arrested. He is absconding. There is a statement of 2 other police escorts who were with this petitioner who has spoken about the conspiracy. Constables are there who were also the gunman to this accused person, accused number 18. Now, my lord, he gets
Great.
Through them he gets executed, my lords.
Great.
Through them he gets executed. The matter is still at the investigation. Only 2 weeks are over, my lord. By that time, anticipatory bail is granted, my lords. And based on this, now everybody is getting anticipatory bail, my lords.
The petitioner is in jail since 29th January 2025. There is no recovery from the petitioner. Allegation is this, that he is the owner of the vehicle. Only 4 witnesses have been examined out of 22 witnesses.
Your Lordship, I'm appearing for respondents.
He was arrested on 29th January 2025.
You are the main person, sir.
Lord, he is the owner of the,
Offences are registered against.
no offense.
You are the main person.
He is the owner of the vehicle, not.
You are the main person in this case, sir. 245.105.
Yes, my lord,
kg
the
of ganja was recovered in the period of custody is 1 year, 3 months only.
1 year and 4
months.
four-
4 months.
Yes, 29th January 25. And out of 22.
2 months, sir. It is too early.
No, 1 year and 2 months.
Yes, sir. It is too early. Quantity is 245. Gangale sir.
But my lord, he is the.
Wait for some time more.
After 3 months, my lord, liberty may be granted.
Wait for some time more. You made all attempt to bifurcate. Huh? Entered into an agreement, gave it, but registered ownership has not been changed.
That is the.
That is right, sir?
Yes.
Am I right?
Yes. My lord, the 6 months.
How many witnesses are there?
22 witnesses out
How
of
many examined?
4 witnesses.
Let us say within 1 year trial be concluded, otherwise you may.
6 months.
You know, it may not be possibly done. You know this thing very well. Okay. After hearing the need counsel from parties at this stage, we are not trying to entertain the present SIP. Based upon the facts of the case, it is directed that the trial be concluded now within a period of 1 year. Otherwise, petitioner would be at liberty to renew the prayer. First of petitioner to cooperate.
Grateful, my lords.
Thanks, Your Lordship.
Wait.
My Lords, item 8, this is an SLP seeking bail. There are two aspects, my Lords. First is about the inadequacy of material against me. There is inadequate material against me. The second aspect, my Lords, everything points out towards the guilt of the husband, and he has been simply let off. He is the person who last visited the deceased.
He is the person who last
Visited the deceased, my Lords, in her premises. She is his wife. The postmortem report shows that the time of death coincides with his last visit. He discovered, my Lords,
time of death.
coincides with his visit, my Lords. The time is approximately matching. The second aspect, my Lords, that he discovered the deceased in a dead condition on 5th evening, but the FIR is registered 30 hours thereafter. And the FIR is also not lodged by him, it is lodged by mother-in-law, who also speaks about the motive, that despite a divorce proceeding pending against them, he would frequently visit the deceased place, beat her, assault her, etc. Now, in those circumstances, Your Lordship, he is not even formally arrested. He is simply detained overnight and next morning he is let off.
Certainly is right. That is right.
Now, my Lords, now the material against me. 7th morning, my Lords, 6th, 7th, intervening night, he is kept in the police station.
Accept the notice, my Lords.
Except notice counter be filed within 4 weeks. List.
My Lords, he has no criminal antecedents. Would Your Lordship, he has no criminal antecedents. Would Your Lordship consider releasing him on interim bail?
Counter be filed within 4 weeks. We are issuing a notice
All right, my Lords.
reluctantly.
Grateful, my Lords.
I'm not understanding. You want the negative points.
No, my Lords. I'm grateful for notice, sir.
We can tell you the complete chart we have. You can look into. Complete chart.
Right, my Lords, have gone through that.
Counter affidavit file list immediate after
Grateful, my Lords.
reopening of partial working days. If some help can possibly you can take a chance.
My Lord, I am for the cavita respondent number 1.
Yes. Yes, Mr. What is wrong in this?
Lordship, I appear for the petitioner. The petitioner
Yes, when
is
it
being
proceedings
dragged into
also.
this arbitration. Let me complete, Mr. Magre.
Please.
Yes,
Uh,
Mr. Khanna.
Yes, the petitioner is being dragged into this arbitration proceeding based on a MOU where I'm not even a signatory, I'm not even a party. For that, one has to refer to Section 2H of the Arbitration Act, which says that it has to be a party.
In this company.
I had in 2018, this MOU is of 3 years later. There are issues which have to be raised.
Uday. Yes, Mr. Uday.
Yes, Lordship, my entire case is on the premise that the transaction has taken place between the petitioner and respondent number 2 on behalf of the company. I hold this particular piece of land which could not have been arbitrated upon because I have not given my consent. What the Honorable High Court has done is they have looked into Cox and Kings and says that this is a complex issue, so they do not go into my role in this particular matter. Now, when one has to look into this, we have to look at Section 2H, read with Section 7, which talks about party. I cannot have been a party because I have not given my consent to this arbitration. I have not given my consent to this MOU.
You are party to the agreement or not? Please tell us.
Lordship, please.
You signed the agreement or not?
I did not sign this particular MOU. I did not sign this particular MOU.
And all objections have been left open for you. You go and raise all these objections. This cannot be looked.
In Section 16, if your Lordship gives me the liberty, I will raise these objections in Section 16, Lordship.
No, sir.
But however, there are 2-3 aspects which one has to look into. This land has been attached by ED. So once the statutory body has looked into it, it's a right and rem. It cannot have been decided in arbitration.
The stage of arbitration. Sorry.
Nothing has been done and he has participated in the proceedings. He is participating in the proceedings. He has raised this preliminary objection.
The petitioner is struggling. Why you are? You want to create more problems? Sorry.
Why should I?
Sorry. Sorry, sir.
May I please minutes? May I please minutes? Unfortunately, minutes, the Honorable Division Bench has failed to consider the fact that none of the documents were proved during the trial before the learned CGIT minutes. All those documents were discarded. No original documents were produced before the CGIT minutes, and adverse inference was drawn for not production of all the documents. But now, Your Lordship, may kindly note only 2 dates minutes. But I filed a writ in January of 1993 alleging that I have been employed through different contractors and I may be regularized. I'm so deeply obliged.
May I please, my lords? My lords, Honorable High Court has gone on a different tangent, my lords.
Issue notice on delay as well as.
Stay may be granted, my lords, other would be. My lords, it's
Can be granted.
it's in teeth of my lords as
You
well.
have to pay. No, nothing, no teeth, sir. If you want to ask, only one clarification is required. Therefore, we are asking. Nothing more in this case. Much more. One clarification with respect to that situation, regularization or period. Nothing. Here it was a 4-year only.
Yes, my lords.
So just you can't say much more, sir. Very little scope in this. We are telling you very frankly. I had dealt with all cases.
My lords,
aware of that.
my lords, I've heard it for good 3-4 days.
To what extent it can be done?
Oh, Lord,
If you want
Rakesh,
to get more benefit, go and we are giving a chance to you.
obliged, my lords, obliged.
We can clarify this and finish it.
No, my lords, I'll leave it to that, my lords. I'd rather have this, my lords.
Pass 2 judgments on this same.
I'll have this, my lords. I'll have this, my lords. Obliged, my lord, deeply obliged.
If we have passed, we would have seen everything.
My lords.
We know this thing. Anyway, thank you.
When I was in item 12, I seek a pass over in the matter.
There's a cross appeal as well.
Only that that home bias may not be in a position to get complaint. So you have come now.
No, my lords. There is merits. I'm being led by a senior. May I request a pass over, please? I'm grateful.
Item 13.
May it please the Lordship. Only a small issue, Lord. Lord, your Lordship will, Lord, decided the Surajmani batch of matters, Lord, and in that, Lord, your Lordship categorically said, Lord, the issue was also framed that only work charge status. Lord, we are not shying away from giving work charge status. We are giving it to everybody. But the executing court, Lord, in an execution petition says, no, you regularize them. Lord, your Lordship, kindly have page 288.
My lords, I'm here on Gavit, my lords. My lords, that is incorrect, my lords. My lords may kindly see. My lords had passed Surajmani judgment on the base. My lords has already dismissed a similar matter, my lords, where they have relied upon, my lords. Their review has been dismissed against, my lords. Kindly see, my lords. My lords may kindly see the grounds in the review, my lords. Thereafter, my lords, that SLP of Gopal Singh also has been dismissed by this court, my lords. That clarification is gone, my lords. My lord, Surajmani was given specifically on the basis of Moolchand Upadhyay, my lord, Moolraj Upadhyay, my lords. Moolraj Upadhyay said first work charge status, my lords, and then regularize. My lords, kindly see at page 289. My lords, may please see page 289, my lords. The review against this order of Surajmani in this particular case has been dismissed, my lords. And this is an execution.
So let us understand this is an execution.
Yes, my
There
lords.
is main direction in this case.
288, page 288 of the SLP paperbook, Lord.
I'm taking, my lords, page 289, my lords.
Now, I'll come to that also. 288, your Lordship. Paragraph 3.
Paragraph
3. 288. Lord, may I just read it? Now, this says the short point that arises for our consideration in these appeals is whether a daily wager is liable to be conferred work charge status after completion of 8 years of service. In other words, whether the benefit of work charge status could be given to a work charged employee after completion of 8 years of service. And this your Lordship decided, Lord. We are not shying away, Lord. We are saying that is not to everybody. Now, Lord,
Sir, please,
I'm good.
you have
I'm good.
taken up the matter.
I'm
You
sorry.
want to say,
Yeah,
taken up the matter.
No.
And then on halfway you left it.
No.
Point was this.
Yes.
So we do not want to shy away.
No, I'm sorry.
We are asking what was the direction, sir.
Your Lordship will have
please
page
tell us the direction,
293. 293. 293, paragraph 8.
Yes.
Laws may read, laws.
Yes, please.
Now it says, however, in order to ally the apprehension of the state as expressed thereunder and to safeguard the interest of the state which otherwise would have burdened the exchequer with extra benefits being conferred on the employees who had not been regularly appointed, this code has, as a succor to the state, restricted the claim, or in other words, modified the order of the tribunal as affirmed by the High Court by arriving at the conclusion that the petitioner appellants therein would be entitled to notional benefits of the order passed by the tribunal and accordingly disposed of the said appeal. It would not be out of context to refer at this juncture itself that the state, in its wisdom, having felt that the subsequent schemes having been formulated and implemented would alter the situation and therefore order dated so and so, your Lordship rely on these previous judgments, then I'll skip through this, paragraph 10, then your Lordship will have, Page 295, for the cumulative reasons A4 stated, we are of the considered view that the dicta laid down by this court-wide order dated 22nd of July 2019 in Ashwini Kumar Supra case, which is based on the judgment of Moolraj Upadhyay, holds the field and would also be applicable to the respondents herein who had approached the tribunal or the High Court seeking similar relief. As such, the respondents shall be entitled to grant a work charge status from the date of completion of 8 years of service. However, we hold that the relief in the present appeals will be limited to notional benefits as explained in paragraph 3 and 4 or Ashwini Kumar's case Supra, so-and-so, and the present appeals stand disposed of accordingly with no order to cause. We also make it explicitly clear that the state in its endeavor for implementing these orders of the tribunal, High Court or this court, having paid the amount in excess, would be at liberty to take such steps as it deems fit without insisting for one-time recovery.
My lords, may kindly see page 2. My lords, please see it too. My lords, please see. Yes, my lords. My lords, kindly see this. That is because, my lords, it's my lords for last. Yes. Kindly see at page 289, my lords. That is the Moolraj Upadhyay scheme, my lords.
Yes.
What my learned friend has argued is in para 4, my lords, taking into consideration the facts and circumstances of the case, we modify the said scheme by substituting paragraph 1 to 4 of the same by following paragraph. Daily wage must role workers, whether skilled or unskilled, who have completed 10 years or more of continuous service with a minimum of 240 days years on so and so, shall be appointed as work charge employees with effect from 194, shall be put in time scale of pay scale in the corresponding lowest grade in the government. Now, my lords, come to para 4, next page. Daily wage master role workers shall be regularized in a phased manner on the basis of seniority, cum suitability, including physical fitness. On regularization, they shall be put in the minimum of time scale payable to the corresponding lowest grade applicable to the government and would be entitled to all the other benefits available to regular government servants of the corresponding grade. Now, in the light of this, my lords, please read my lords' direction at page 295, which my learned friend just read, my lords. In Ashwani Kumar, only modification was, my lords, that they had given notional benefits. In these cases, my lords, the High Court has given benefits for last 3 years. That, my lords, have taken away. Please see at page 295, para 10, my lords. For the cumulative reasons aforesaid, we are of the considered view that the dicta laid down by this court, white order dated so and so in Ashwani Kumar case, which is based on the judgment of Moolraj Upadhyay, holds the field and would also be applicable to the respondents herein who had approached the tribunal or high court with seeking similar relief, my lords. Now, kindly see my relief which I had sought, my lords. My lords, may please come to page 174. Nothing more has been modified, my lords. And my lords, what is the argument before the High Court? They say this was wrongly tagged with the Suraj Mani case, my lords.
474.
174, my lords. I'm sorry, my lords, there's some mistake. I'm sorry, my lords, there is some mistake by my pagination, my lords. 47, where my prayers have been reproduced.
Yes.
And one which were allowed by the learned single judge at 148, my lords.
Yes.
Issue a writ on mandamus or other appropriate relief, direction, order or direction directing respondents to grant work charge status after completion of 8 years of regular daily wage with effect from so and so, and regularize the services of petitioners with all consequential benefits, my lords. This is what my lords have done in Suraj Mani's case, my lords. Relying upon Moolraj Upadhyay, my lords have said only what we are modifying is the notional aspect, benefit aspect, my lords, that we will get only notional benefits, my lords. Nothing more has been done, my lords. And my lords, this matter went, Suraj Mani, my lords, in this particular case of Santaram, my lords, the state filed a review. Review has been dismissed, my lords. Kindly see the grounds of review, my lords, where they rely upon Gopal Singh, my lords. That SLP also has been dismissed by this court on February 26, my lords. Very recently, my lords. I'll show the judgment. My lords, may kindly see the grounds of review, my lords. They have been reproduced in the impugned order itself, my lords. Kindly see at page 7, my lords. And page 8. For that, the order dated 16/5, this honorable court in special leave petition, diary number so and so, entitled State of... My lords, page 8 of the impugned order, my lords, where the grounds of review has been reproduced, my lords.
Yes.
At C, my lords. And my lords, one more thing. 525, this Honorable Court petition number so-and-so, entitled State of Himachal Pradesh versus so-and-so has issued notice. It is most respectfully submitted that the case of Gopal Singh is on parity with the present case of the petitioner state. Now, my lords will have this order, my lords, where my lords.
Yes, my lord. Now, Lord, may I just
One
say-
more thing, my lords.
Lord, what-
One last thing, my lords, then you may start. And it is very unfortunate, my lords. My lords have seen that mentioning also where they said at every stage what the state is doing is we are taking an excuse either by they say that we are filing a review, or they are making a statement that we will comply with the order. In this particular matter, my lords, in execution petition, my lords, on 11/3/26, my lords, if I just can read, Learned Advocate General on instruction submits that steps have been taken for implementation of judgment so as to regularize the petitioner in the project as a matter personal to them. On instructions, my lords, the Advocate General makes a statement that he is complying with, and he takes time, my lords, and on 30th March, they filed this petition here. My lords, this can't be done, my lords. I've worked for 30 years or more, my lords.
Yes.
Lord, may I just say this? Lord, my learned friend was also there, Lord, when these Suraj money matters were heard. Lord. Now, Lord, in those batch of cases, Lord, your Lordship restricted it only to work charge status, Lord. Now, they should either say, Lord, that
No reason to do.
no, your Lordship, kindly bear with me for a minute. Lord, kindly bear with me.
It's all hard news, sir.
No, Lord, I am only saying, Lord, since they did not agitate it there, Lord. In Suraj money, they accepted Suraj money. We also accepted.
To go like this, sir.
Lord, your Lordship, kindly see, Lord, what was the main issue framed in Suraj money? Lord, your Lordship, kindly, Lord, 1 minute, your Lordship, bear with me. Lord, your Lordship, this will, Lord, create a huge financial implication, Lord, for the state, Lord, because it was never agitated. The regularization was never a part of Suraj money. I'm grateful.
May I request my lords to take the file of 14.1 first? Because that's the petition under section 11. My lords, this is squarely covered by my lord's judgment of Maharashtra state
Have you seen the terms of the agreement?
Yes, yes.
Was it based on the LOI and
Yes.
NBCC?
There were two aspects.
You have subsequently entered into an agreement where you have specified that there is a agreement.
My lords,
Yeah, I have
kindly
not
have.
seen that.
No, my lords, I'll clarify.
See, madam, I am aware.
My
that,
lords,
we are-
kindly
we
have,
to go.
kindly have an extra P1.
But we have written now.
That is why, my lords, I'm relying on that, and I say it is
Understand,
squarely,
madam,
it is
we know
squarely
that where
covered.
you will catch hold us.
No, let's not, my lords. It is in my favor, my lords. I'm citing that.
Clause 60, where is that page
My lords,
number?
kindly have
Document
P1. My lords, kindly have.
Page 171 of the.
My lords, I want to first come to the NIT. My lords, I am NBCC. I am the project management consultant of NTPC.
I have seen both compared with that judgment and this also.
Well, it's just 14.1. Well, it's 14.1 and the pages.
I'll just look into.
Yes.
You are arguing, we have to look into.
Yes, yes.
Page number.
My lords, kindly have page number 38, which is the 38 in 14.1.
38.
Now, clause 1, my lords. This is the NBCC's, my lords, NIT.
Yes.
Kindly see.
We are aware.
Yes, one says NBCC Limited invites sealed bids for construction so and so. The all terms and conditions as contained in the tender issued by NTPC to NBCC shall apply mutatis mutandis except where they have been expressly modified. Now please come to clause 5 of that is at page 52. These are the set of contract documents. My lords are there with me?
Yes, sir.
Page 52.
Yes.
The following documents.
Yes, sir.
NBC's SCC, yes. NBC's documents are NIT, instruction to tenderers, then NBCC's SCC, then minutes, and then the second set of documents are GCC, SCC. These are all NTPC to NBCC. Now kindly come to page 54, which is the order of precedence of the documents, how the documents will be read. Kindly have at 3, NBCC's NIT, ITT and special conditions of contract. They have to be read first. Now come to the jurisdiction part, which is most important, which is clause 20 at page 61. May I read, my lords?
Yes.
It says the agreement shall be executed at New Delhi on non-judicial stamp paper purchased in Delhi, and the courts in Delhi, New Delhi alone will have the jurisdiction to deal with the matters arising therefrom to the exclusion of all other courts. So this is what is the NBCC's document, my lords, which is relevant. this is also a two contract, tender, because the first is the NTPC and NBCC, the second is the NBCC with the present respondent. Now, arbitration clause is P2, which is the NTPC's GCC. Yes, I know, I've already. Now, arbitration clause, which my learned friend is relying upon, is annexure P2, which is the general conditions of contract for civil works. It is a general, my lords, for all civil works of NTPC, and there it is clause 56. I would want to read that also in toto, because this is also, my lords, for the operation of law, this can't be now followed. Why? I'll just read that, my lords. Kindly come to 8 lines from the top. May I read, my lords?
Yes, page number?
Page number is, my lords, 272. I'll read the entire clause. Arbitration. Except where otherwise provided for in the contract, all questions and disputes relating to the meaning, etc., designs, drawing, materials used on the work, or as to any other question, calm, right, matter, or thing whatsoever in any way arising of or relating to the contract, design, drawings, specifications, estimates, instructions, orders, or these conditions of otherwise concerning the works, or the execution, failure to execute the same from arising during the progress of the work or after the completion or abandonment thereof shall be referred to the sole arbitration of the General Manager of NTPC Limited, formerly National Thermal Power Corporation Limited, and if the General Manager is unable or unwilling to act, to the sole arbitration of some other person appointed by the Chairman and Managing Director NTPC Limited, willing to act as such the arbitrator. There will be no objection if the arbitrator so appointed is an employee of NTPC Limited and that he had to deal with the matters to which the contract relates, and that in the course of his duties as such, he had expressed views on all or any of the matters
What do you
in
want to
dispute.
say? This is a clause of arbitration. What do you want to say?
I
on this?
say that this is not applicable because what will be applicable with the will be the NIT, which is NBCC, which is my contract with the respondent. This contract, this arbitration clause is there in the general conditions of contract of NTPC. I am the project management consultant of NTPC. So NTPC gave the work to me. I have entered into agreement with the respondent, and in my agreement there is no arbitration clause. 56 is in the GCC of where I have entered into contract NTPC.
Which, suppose we go by the NIT.
My lords.
NIT issued by?
NIT is by me, NBCC.
All right, you issued an NIT.
Yes.
You gave a contract to?
The respondent.
Respondent.
Yes.
How NTPC comes into the picture?
Because that entire work is from the NTPC. I am the project management consultant of NTPC. They have the general conditions of contract. That is for me. Their fifth arbitration clause is there. I have entered into contract with NTPC. Now, when I have
who is going to be affected by this?
My lords, the NIT says it has to be the courts in Delhi which will have jurisdiction. The NIT does not have any arbitration clause.
Asking of 2 points. First, we are asking of it's a matter of 14(1) is a matter of appointment of the
11. Yes, appointment of the arbitrator.
Section 11, we have to look into the basic contract.
Basic contract.
So basic contract was?
My lords, kindly have the NIT, and then the contract was, which was entered was the agreement at R5, 14/9/2007. And there is no incorporation. It is a general reference. In the contract, my lords, there is no incorporation, which is the bedrock of my lord's decision.
Spirit of that judgment which we delivered.
Yes.
What we delivered is?
My lords, 7.5 says.
NIT flows, the conditions, impact thereof has to be looked into.
Yes.
Because we distinguish the judgment of Justice Surikant.
Yes.
All right.
I know.
So we taken this from that,
yes,
and then we have to go on to this extent.
I bow down.
That situation,
I bow
we
down.
say no. There is nothing is there.
Because my lords, very categorically.
That you can't take advantage of that.
My lords, what I am showing is that there is no arbitration clause between both of us. The agreements does not provide for it. Then also, my lords, there is a general reference. Kindly have 7.5 for a moment.
Heard you, what
My lords,
I
want to show.
To say much more.
My lords, clause 10 says the order of precedence of documents in which the NIT comes
no
first.
reason to interfere.
I'm so blessed.
And the subsequent is of the change of the arbitrator. 14 is a change of the
My lords,
arbitrator.
this issue can't be arbitrated because there is no arbitration agreement, my lords. That is my precise submission.
We see no reason to interpret. No.
My lords, can I only show the agreement between,
I am
my
aware
lords,
of that.
only one, my lords, I have,
Certainly judgment, I know where is the flaw
my
is lying in
the,
that.
my lords, the facts of this case, I just want to show
Next,
one more
madam, please.
document.
Next.
Lords, can I just show one
Next
document?
case.
I'm so blessed.
Well, it's then I may be allowed. Well, I may be allowed to raise this issue
Objections. Fine.
as an objection.
Arbitrator has already given them liberty. They were supposed to file the section 16.
Certainly, this is always a liberty.
Of course, ma'am.
Well, it's
Always,
just
there is always a liberty with them. So this cannot be at this stage cross.
No, of course not, Manoj. That's exactly
You are aware
what I'm
of
saying.
this,
That's
yes,
exactly
we
what
are
I'm
aware.
saying.
But just because we have come here in SLP, Malats, I'm just taking that.
See, no reason to interfere. However, the legal objections are available to the petition. Maybe
Well, it's
permitted to be raised before the argument. Anything else?
well, it's, there was one
Period
document
half.
I want. No, Malats,
That's half.
I thought, Malats, this requires little attention. If Malats would only see the annexure
If I
5,
should not have seen that judgment thoroughly,
Malats have.
yesterday, the first instance night, I did it. Then I asked to my colleague, that law clerk, please come with that judgment, see that nicety of both. I put it with a lens.
Well, there can't be any doubt that Malats goes through each and every document.
Thank you.
I'm so blessed.
I'm grateful.
I don't think you would see that there has been, the Delhi High Court has given a
What is this document, sir?
May I explain?
We can understand
Milords-
that you taken this document is produced by the owner in the police station. You taken a copy thereof, you rely upon that document.
Yes, Milord.
Fine. So now, on the basis of the same, if PN recovery is directed, there cannot be any problem to you. Now, what the High Court says is, the document may produce by the owner, but it's a forced document. Then how you can claim on the basis of the same insurance company? These are two situations.
There are two situations. Milords, in fact submitted a judgment in the night, Milords, Sobit Singh, where Honorable Justice Mirdha of Delhi High Court has given suggestions, Milords, with the assistance of the senior counsel, Mr. Gopal Subramanian, senior counsel. Milords, there it was said that in that case, Milords, paragraph 7.18, Milords, that Milords, at the threshold in the CGM's court, the police should have confiscated and sold off the vehicle and given the money to the person who has died or injured, Milords. And here there was a folly before the CGM's court, Milords, that everything was done and they showed and they made an inquiry before the insurance company.
How this is relevant? Can I put in different way, sir?
No, Milords, I'm submitting, that's a suggestion given in the.
Submitting suggestions, keep suggestions aside.
That judge.
Please listen for a minute. MACT relying upon the fact that a document which is produced by the claimant is a document seized by the police from the owner. On the basis of the same, the vehicle which was involved in commission of the offence has been released in favor of the owner. That was the insurance policy. They say liability of insurance as well as so and so, pay and recover. When it came to the High Court said that the insurance company has taken a plea that this vehicle is not at all insured and this is a forced document produced by him. And on the basis of the same, this plea was accepted. Suppose a document on the basis of which the claim is surviving, in which a finding is recorded, if it is found it is to be forced, how you can rely upon the information, sir?
May I submit, Milords? May I submit, Milords, on this? Because what happened was that the truck was seized and it was lying in the police station. It was lying in the police station. Before the CGM, there was an inquiry held. And the police officer had to, under the investigation or inquiry, whatever, he had to only go to the insurance company, which was in the same town.
He goes there, finds that the insurance certificate was right. And my lord, one thing has also come here.
There is a document you have filed here, inquiry held and everything is done.
Oh, that was there in the statement, lordship. Can I take to page 29, my lord?
Document
Page 29, my lord, they have said everything. Trial court has decided in my favor. Lordship, what has happened, lordship would see the...
Sir, in the manner in which you are arguing, trial court decided in my favor, we have not seen those things, sir.
That lordship
You
wants
feel
to...
so?
Trial court, page 29, my lord. See, paragraph.
Court decided what the High Court said, which is a judgment here.
My lord,
The High Court said the document initially itself is a forged document.
But my lord, with due respect...
It will be given to you.
Lordship, with due respect, my lord.
We are asking you, you are saying some inquiry was conducted and said it is not a forged document. Where is that document before us?
That I'll file, my lord. That I'll file, my lord. I'll file.
Don't
I'm
make
not
it
saying...
like this, that whatever you will say, we'll accept it.
No, I'm only saying, my lord, that the...
You make out the case that the finding which is recorded by the High Court, if we look into these documents, cannot be sustained. We can understand.
Yes, my lord, I'll do that, my lord. And second thing is, my lord, he had another 3 trucks. He had 3 trucks. The High Court has indicated, not in this truck.
Counsel for the petitioner prays for him done. We are not interested to dismiss everything.
My lord.
We are interested, you have some claim, only then can be.
My lord.
Otherwise, you cannot take with us.
My lord.
After hearing learned counsel for the petition, learned counsel for the petitioner prays for him done. 4 weeks time to file the 11 documents regarding holding an inquiry by the investigating officer on the point of the insurance policy.
Well,
Please have those 11 documents be produced. So list thereafter.
BC by learning journey through BC, my lord.
देख रहे हो BC पे कोई है?
Yes, sir.
My colleague is joining through BC, my lord. This. Item 16.
Yes, sir.
My lord, am I visible?
Not visible.
Okay.
No.
My lords, only 2 seconds, not more than that, my lords. I rest my case. I board on to this honorable bench judgment dated 24th April 26, case of Vinay Deshmukh versus Natwar Lal, in which this honorable court has said that the honorable High Court cannot cross or cannot rely on material evidence in 227. In the present case, the petitioner has taken off the records which were not there in the trial court, and based upon this honorable court has passed a judgment totally brushing aside the reliance of Rajneesh versus Neha. What all precedent this honorable apex court has read, that not even a single word in the judgment of High Court says that based upon assets and liabilities affidavit of both parties, the honorable High Court comes to this figure. The trial court has rejected the maintenance because the documents were not there on record. The trial court has also said the documents that relied by the petitioner before this honorable court were there on record, and none of these documents are refused or denied by the respondent in the trial court. Now, the honorable High Court relies upon all these documents or YouTube, specifically a YouTube channel. My lords, the apex court has relied that the assets and liabilities should be referred for the maintenance, and the High Court entirely relies upon the media presence. My lord, in the word of
I can. It was tried by a retired judge of the High Court. It didn't work out. So it didn't work out. I have no difficulty in trying at all. But I think was 2018 to 2026, 8 years. Have you filed divorce? Has there any divorce petition, etc.?
yes, it's pending. It's filed
By the other side. So Milos, I think it was tried. It was not worked out. For 8 years now, Milos, this is.
How much are you depositing some amount? Then we can thought of something. Otherwise, we will not.
I've been depositing, my lords. Even on last Monday, I have deposited 5 lakhs, my lords. I am under heavy areas. I am not able to sustain this amount. 5 lakhs I have deposited on Monday. Last Monday I've already reported.
For a minute. What is the total sum is coming? Suppose we calculate on the basis of 3 year, 18 to 21, 21 to 24, then thereafter 2075. So suppose we thought of it that yes, you really want to bona fide man, you want to do something.
I
then
agree.
tell us how much amount comes and how much you have deposited. Please tell this thing.
Roughly or
Can I give the figures?
Yes.
Page number 75 to 76, the figures are there in the SLP. Page number 75, 76. The figures are already there.
How much it is coming?
Can I indicate that's
It
only
is 16 odd lakhs. Apart from this, 5 lakhs I have paid on 18th of May. I've already paid 5 lakhs. Apart from this figure.
This you deposited, what we are asking learned counsel. Suppose we apply the judgment as directed by the High Court.
Yes.
If we apply, then what would be the amount come?
It is 74 odd lakhs. 74 odd lakhs.
He is saying 79 lakhs. How much out of that? Suppose you deposited this much amount which you are offering, which you are saying, this is of 16 lakhs approximately.
Yes, actually 12 because 2 checks bounced. So 12 lakh 20,000 is what I got in 8 years, Milots.
My lords, I was in jail. My lords, I was in jail and they were already, lockdown was there. I was in jail. That's why I was not able to pay, my lords.
Milots, Lordship will ask in which offense he was in jail, not at my house.
That's not a problem. See, offense, it's not proved. When it will get proved, then I'll say. I wholly have reliance on the honorable judiciary.
You listen for a minute, sir.
Yes.
Are you interested to deposit half of the amount?
Yes.
Which
My
is
lords,
this time within a period of 8 weeks?
My lords, it's beyond my capacity. I'll deposit 5 lakhs, my lords. 5 lakhs I concede, I'll deposit 5 lakhs. My lords.
No interference.
My lords, please, this is the last court, my lords, with folded hands I'm coming before this honorable court.
My lord, saying to you, sir, we can also hold our hands to you.
I know. That's why I have totally relied. My lords may raise some amount beyond 5 lakhs. I'll pay something, my lords.
Are you interested to deposit half of the amount within 8 weeks?
My lord, half of the amount will be too much, my lord. At least give me time. I'll pay 10 lakhs. 10 lakhs I'll pay, my lords.
Nothing can be done, sir. Nothing can be done.
My lord, at least consider some amount. My lords.
Why, sir?
50% amount is too much beyond my limit. That's why I'm saying.
Yes, please.
But my lords, I'll reasonably try to deposit 25 lakhs. 25 lakhs I'll try to deposit, my lords. 25 lakhs is a reasonable amount for them also. We are squarely reaching there.
In addition to whatever he has
lakhs.
deposited, 25 he will deposit.
20.
I take it, Milos. I don't even need instructions. I'll take it as call at my level.
Yes. Okay. Learned counsel appearing on behalf of the petitioner. After arguing for some time, submits that the petitioner is ready to deposit 25 lakhs.
He can pay.
The amount already deposited. Already paid.
He can pay me, Milos. There's no dispute on this.
Let them come deposit.
No, Milos, no difficulty. Whatever your lordship says, I have absolutely no difficulty. Deposit with the registry of this court, Milos.
Yes.
We are saying,
Yes, Milos. No difficulty.
25 lakhs within a period of 8 weeks.
Correct.
We take this as a statement on record.
Milos.
Yes.
Full stop. Issue notice returnable in 8 weeks. In the meantime, for the remaining amount, subject to payment of the regular amount of maintenance.
Milos.
That's good. Application of the impugned award shall remain state.
Right. And if he doesn't deposit, Milos, then lordship will just make an order so that there's pressure on him. That's all.
Full stop. In case the amount as offered is not deposited, this court may pass appropriate orders on the next day.
Grateful. Execution arrest warrant they have issued.
Yes. Execution we have said state.
The remaining amount, it will remain state subject to deposit of current. Grateful.
I know.
So being led by learned senior counsel Mr. Bajantri appearing through VC Malay.
I'm appearing for the petitioner, my lord.
Yes.
matter relates to change of cadre from the post of assistant executive engineer to that of assistant director town planning. Rules of recruitment are down. It is at page number 61, my lord. Lord, I have prayed for interim order. I had the benefit of interim order from
What
the
interim order?
to continue in the post of assistant executive engineer.
At present, with respect to posting, the status quo as it exists today shall be maintained till next date. Date lagana hai.
Please,
Grateful. May I request for a passover, Lords? The Lordship should be pleased to grant a passover.
Returnable in 8 weeks.
We are in caveat, Lord.
The status quo as it exists today shall be maintained by the company.
We are
I'm so
accepting
grateful.
notice, Lord, in the caveat.
You are for?
I'm for the R1.
Please sit, sir, in this case, you have to sit and materialize the things. Otherwise, there is no purpose.
Lord, this is a concurrent finding for the joint
But we
family.
have understand, sir. Even then we are issuing a notice, something we would have found.
Yes. I will file reply.
Better is sit there, and so far as that share of these persons are concerned, you find out if you have some deliberations, make it some deliberations, take some amount and give it and finish it. Unnecessarily fighting for the things.
Very good. I'm accepting notice, Lord, on behalf of our. My Lord may have any returnable date.
With that instructions on the next day, go for
Yes.
mediation.
Yes.
In the meantime, status quo as it exists today shall be maintained. Number, respondent number?
R1.
R1 only, remaining corresponding factor.
Grateful. Any date not returnable. The reopen. Great. Please, Lordship.
Lordship, leave to defend application was allowed by the learned rent controller, which has been upset by the impugned judgment, Your Lordship.
Yes.
When there is, admittedly, Your Lordship, there's a finding, categorical finding in my favor in the impugned judgment. Kindly have, Your Lordship, page number 6, para 16.
What would be the impact of that suit? Nothing.
No, Your Lordship, that suit is still pending in the sense, Your Lordship, first appeal is pending.
Make any difference if you succeed there in my own judgment with Justice Indira Banerjee, you can look into.
No, in fact,
Delhi.
Your Lordship may kindly see, there is an agreement to sell in my favor in 1990. There is an agreement to sell in his favor. It is not that he has got a sale deed.
Different issue here, it is nothing can be done here.
No, Lordship may kindly have para 16 of the impugned judgment for a minute.
Nothing can be done, sir, here.
Lordship, one line only, Lordship, I'll read. Para 16 of the impugned judgment, page number 6, Lordship.
Yes.
In view thereof, there is no gainsaying that landlord-tenant relationship between the parties are not established. So once, Your Lordship, there is no landlord-tenant relationship, under Delhi Rent Control Act, Your Lordship, the petition is not maintainable. Therefore, on this ground only, Your Lordship, the learned rent controller granted me leave to defend. It is not that I'm willing to go before the learned rent controller and contest the petition, establishing my title, Your Lordship. And it is not that I am agreeing to his landlordship, Your Lordship. Kindly see 10th June 1996, Your Lordship, there's an agreement to sell in my favor. In the meanwhile, execution is stayed, Your Lordship.
In the meantime, status quo as it exists today shall
Deeply applied.
date लगा दीजिए.
Deeply applied.
Date लगा. Item 20.
Please, Lord. Lordship, in this case, the plaintiff claiming herself to be daughter of two brothers, that is Rama and Bulau. She has filed a suit before the trial court saying that she is the daughter of the Rama, and in the plaint she stated to be the daughter of Bulau. And on the basis of the contradictory finding, the trial court had
You don't want to give anything to your sister.
Yes, she is not my sister.
You can say so, sir.
Actually, she has not.
You can say so.
Actually, Lordship, she has not proved at all.
Say so, sir.
She is totally outsider. There is no difficulty.
So outsider, no, sir.
There is no difficulty.
It's a very peculiar case. In this peculiarity, if you see, Phoon Kumar is first married with the Rama.
Yes.
All right, this Rama, then Rama died. Then
Yes.
this Phoon Kumar married with Bhalai.
No, my marriage is not proved. Even Fulkuvar, see.
Who are you, sir? By the way,
No,
you are illegitimate.
I am the son of Bulau, second son, second brother. I am the son of the Bhulau Lordship.
You see,
I am the son of the Bhulau.
now they have Bhagavad and this Rama. In fact, it is being said this Rama and Kundu was having son. So this is a peculiar case. This
Fool Kuvar, the marriage of the Fool Kuvar with
who are you,
Bhulau.
sir? Then, if Ulkar is not there, who are you? Marriage illegitimate.
I am the son of the second.
Sorry, sir. You must be
I am the son
happy.
of the Bhulau.
Half has been given to you. This is enough.
No, Lordship, there is no difficulty if she is my sister, Lordship. She is totally outsider. May kindly consider. There is contradictory statement made by the plaintiff, Lordship. The trial court has dismissed this suit, Lordship.
Sir, thank you.
Lordship,
Thank you, please, sir.
much obliged. The Lordship, there is some delay of 60.
Thank you, please, sir.
There is some delay, Lordship. I am requesting to condone the delay. 65 days.
Delay condone.
Much obliged.
Happy. Half succeeded. Huh? Thank you.
Please. My lord,
Why you cannot go in a division bench, sir? Why you cannot go in a writ appeal before High Court?
my lord,
Kindly see page number 1, petition article 226 of the Constitution of India. Go in High Court.
please, my lord, I may kindly.
Learned counsel seeks permission to withdraw this SLP with liberty to file the writ appeal before the High Court. Dismiss as withdrawn.
I'm grateful.
22.
Lordship, and for the petitioner, Your Lordship, the respondent in this matter has been filing several IAs when the matter has been reserved for judgment, Your Lordship. He has filed IA for recall, IA for reopen of the case.
Even in a civil case. In the meantime, further proceeding case number so and so. Can you give a case number and court number?
Yes, Your Lordship.
Stay. Till next day. Date लगाना.
Your Lordship may permit Dusty also.
In addition, Dusty permitted.
Obliged, Your Lordship.
23 days the letter.
My lords. It's clearly called by your own judgment, my lords, Radheshing, my lords. And here, my lords, is clearly a civil suit.
Mistakes, sir.
No, I'm not saying so that.
If you
But
show
kindly
our
see the
mistakes,
sale. Kindly see this.
If you show our mistakes, then we can.
No,
improve
I'm just citing one judgment of
And if
your.
we improve, then you will understand what.
No, my lords. Actually, my lords, you are.
That would be.
You remember everything very clearly. That's why I just said that judgment. And my lords, kindly see the sale deed, my lords. In the sale deed, there is no plot number is mentioned. The only kindly see page number 26, my lords. And see.
Take all these defenses now at the appropriate stage.
My lords, kindly, my lords, actually what happened here, my lords, there is a land, my lord, open land. Now he wanted some different plot. Otherwise, give me the money. And he filed this criminal case as well as filed a recovery of the suit also. The suit is pending. Kindly see that.
You are pointing out a finger on others. They are pointing out a.
That is a civil dispute, my lord.
Sit there.
And 2016 to 22, he is.
No, it is not a
My lords, here is that.
Civil, sir.
My lords, kindly, one minute, my lords. Two at a time, two litigation cannot be run. He filed a recovery suit as well as, kindly see the page number 29 for a moment, my lords.
That is entirely different.
And land is there. And he is in position, my lords. He wants a different land. My lords, kindly appreciate it. Page, my lords, criminal as well as civil, my lords.
Right, sir, thank you very much.
29 page number, kindly see the
Thank you
29
very
page
much,
number.
sir. Thank you. You go already. We are not inclined to interfere. However, the dismissal of this SLP could not debar the petitioner to take their defense at appropriate stage during time. Thank you.
My lord, to civil
Thank you,
and
sir. You must be happy by this. Otherwise, 25. 25. Are you ready to deposit this amount, sir? Yes, ma'am. I will deposit. Okay. Issue notice. Subject to deposit of the entire amount within a period of 8 weeks from today.
4 weeks, ma'am.
8 weeks from today. What more you want, sir? Without even opening a word. The execution of the impugned judgment shall be ministered. Full stop. The amount for deposit. पहले में कुछ पहले में किया था ना, वो भी deposit करके short term.
Before the trial court, ma'am? Before the trial court, ma'am?
Yeah, with the registry of this court. 26. 26. Password. 27.
High Court totally ignored the specific provision that the offences are compoundable. Madam, can you see the? So, well, if your lordship is issuing regarding this, then only to number
Let
one.
these things may come. Then thereafter, when it will be dealt with, then some issues may come.
Lordship may can be, well, stay in the meanwhile because the reason. Well, the High Court had directed that all those FIR which are registered in the past, they should also, investigation should be closed regarding that, they should be sent back.
Sir, can we do anything today at this stage without the other side? Notice on
Well, they are not concerned with it.
yes, notice on stay also. Wait for
Well, a permission to file SLP and the deliver.
permission.
And a deliver.
Permission.
Your lordship may give a fixed date, well, because of the reason that otherwise.
Sir, it will come.
So grateful.
May play this on the even if the allegations are taken on face value, it would at max be the violation or infringement of patent. It, in my humble submission, would not be forgery or cheating as has been alleged, my lords, or that of copyright. My lords, if my lords may kindly have.
So have this same option. Go and raise all objections, whatever is available to you, Mr. Upadhyay.
My lords may kindly have 39 for a moment. The FIR, 39 for a moment. My lords, in allegation itself, it says, for a long time, information was being received that in Umaria, Dongria industrial area, there is a PVC pipe factory of Hiker's brand company by Polyacid Pipe Industries, in which instead of putting its own brand, the pipes are being manufactured and sold by putting illegal ISI mark of Jain Irrigation Company and Super Jain as well as other brands, in which the name of Jain Irrigation Company is getting tarnished and consumers are suffering loss. So, my lords, in my humble submission, this entire allegation does not satisfy the ingredient of 420 or 467, my lords.
Go there at this stage of charge. Or move appropriate application for charge. Okay, after hearing the counsel for at this stage, after hearing the counsel for the we are not inclined to entertain the present witness. However, we लिखना dismissal of so and so. What लिखा है ना एक case में, they can raise objections.
Grateful. Grateful.
May I please, your lordships? My lord, it's an acknowledged consensual relationship, my lord, on the false promise of marriage. My lord, there is a first closure report was filed, marriage took place, my lord. Subsequently, my lord, they continued lived together for some time instead of withdrawing that matter, and once, my lord, the IO submitted the closure report. Then, my lord, she said that I want to proceed with this matter, my lord. Subsequently, I approached to the Honorable High Court. Honorable High Court should have granted me, my lord, the further trial of the court proceedings, my lord. Stay of the trial court proceeding. Honorable High Court, if your lordship would see the impugned order for a moment. Plus, may I?
Yes.
May I please, your lordships, kindly come to the page number 1, my lord. This is.
You are so early coming fast here.
Because
Court has not said anything.
Ultimately, my lord, summons have been issued, cognizance has been taken. I have been summoned. I have been called to appear, my lord. A summoning order I have placed on record. Your lordships, kindly come to
What would happen?
page 81, my lord.
Yes.
I will face trial in a matter which is, my lord, purely consensual relationship, and, my lord, the High Court on once. Plus, kindly come to, my lord, cognizance order, page 81. May I read, my lord?
What was your petition before the Allahabad High Court?
Which was for quashing, my lord.
You say that it was a consensual relationship. Either the other side may come and say, yes, it was a consensual. Otherwise, at this stage, merely on your defense, this question can be directed to Mr. Dubey.
It's not a case, my lord. Lord, here, if you that's why impugned order has to be seen for a moment, my lord.
What is the order which you are challenging today?
Because that's so.
Please, what is the order which you are challenging?
Because Honorable High Court. Yes, my lord. Yes, my lord. Yes, my lord. My lord,
you are challenging
Shri Vishal Pandey, learned counsel for the applicant. Shri Raghavendra Pratap Singh, learned counsel for the opposite party number 2 is present and seeks time to. This is prosecutor's counsel. file counter affidavit and submits that the allegation of victim is the accused applicant has entered into a marriage merely to weaken the content of the FIR. He further submits that divorce proceeding is also pending between the accused and applicant and victims. He seeks to file counter affidavit. My lord, 1A, what I am seeking before your lordships, that my application be decided. What High Court should have done, my lord, on the very first day, they should have heard my application, my lord. This order says, while issuing...
What application?
My lord, the application for stay, my lord, kindly come to...
Let them consider, we'll say.
My lord, page...
Okay. Let me consult for the petitioner and just sealed the order. Dated. What is the date of this order?
Date is 16/3/2026, my lord.
16/3/26. By which case has been fixed on 23/3/26. Full stop. It is the contention of the petitioner that the application for stay has not been, application granting stay has not been decided. However, the court may look into the same. Court may call upon the said application and pass appropriate orders at the earliest.
Time period we fix with great respect, my lord. Otherwise, a 24-year young boy, my lord.
We should issue the direction to the High Court.
No, my lord,
besides
not
the
direction, my lord. With great respect, my lord. With great respect, the time, if a man 4 weeks at least, say, my lord, that would help my purpose, my lord. 4 weeks, my lord.
Thank you. Nothing can be done.
Grateful, my lord. Deeply obliged.
Pass over in this.
That one of the person who was not a party came to this court in SLP number so and so, which was not entertained. However, after hearing learned counsel for the petitioner, taking that the issue appears to be a larger or a society in the state of Maharashtra, we issue notice in this SLP, returnable in 8 weeks. Delay cannot happen.
Great. Obliged.
Are you accepting notice, mister?
I am accepting for respondent number 5 to 8, my lord.
You accepted, my brother is saying that some issue is there.
Yes.
So let us see the larger issue is there.
I was also going to submit my
Are you appearing in this?
Yes.
We look into this some larger issue. What the society says that one case, the person who was not a party, he came. We are saying, sir, that's how we are saying.
But there was a petition.
We have said, sir, we are, उसको भी restore कर लेना, उसको भी SLP को connect कर देना.
No, 19/4 is the date on which there was a party which was before the High Court, which was also there before your lordship, 19/4. And both those special petitions were dismissed. It is up to your lordship, no issue. But it was not only one which had.
What do you want to say?
The person which was.
You want to say dismiss it?
I'm only finding a factually correct statement that person which was party before High Court, which had also come in SLP, which SLP is also dismissed.
वो मत लिखना. वो लिख देना. One SLP came, but looking to that was dismissed. However, at appropriate stage of moving an application that may be revived. उसके बाद लिखना. वो last में लिखना. उसको ऊपर लिखना. Since a larger issue is in after hearing so and so, और वो नीचे वो डाल.
Grateful.
Your Lordship, the mediation proceedings are still continuing between the parties. I request that the matter may kindly be listed sometime in July.
July, August.
July, Your Lordship.
July is some.
Your Lord,
Astrologist has given a time.
Your Lordship, I'm requesting.
Astrologist has given a time.
No, Your
It will
Lordship.
come in August.
I am obliged.
Yes.
Lordship, I am seeking passover in this matter.
My lords, my uncle was the original owner.
How much delay, sir?
Delay, my lords.
How much delay? How much delay, sir?
514 days.
514.
Yes, my lords. So the reason being, my lords, the petitioner was unwell, my lords, and he is in a village. So
Every day
the lawyer.
He was unwell for 514 days.
No, my lords. The lawyer.
Let him remain unwell.
My lords, may kindly hear on merits also, my lords. At
Let
least.
him remain unwell, sir.
And he stays in a remote village, my lords, in Karnataka. I could not.
That doesn't mean that.
No, I appreciate that.
For partition, you are contesting everywhere.
Yes.
And now, whenever it is to become in the Supreme Court, you have become unwell.
No, reason being, my lords, the lawyer who conducted the matter.
I don't know what is the lawyer did and what you did, sir. Nothing is there in this.
My lords, on the merit, my lords, otherwise,
Nothing in merit itself is nothing is there.
No, the written statement of the defendant number 2, now I filed as annexure P1, my lords. It specifically says that there was a sale date.
Okay. Dismiss on the ground of since no plausible bona fide explanation, sufficient explanation is available. Dismiss on the ground of delay. There is a delay of 514 days. So and so is there. Next.
Oblige, my lords.
56.
56. I begin with I seek my lordship's apology. My learned junior had been able to fish out in the morning. 2 persons were granted anticipatory bail by the same honorable judge. Can I? She has been able to fish it out.
Can we give you another order? We have dismissed SLP of the co-accused having the similar role. We. In the same case.
This versus that.
You can take this also. Sir, you have seen that. You can see this also.
Yes. And another was the larger group, Milord. I belong to the larger group. If he's Milord from the larger group, then of course I.
Case of anticipatory. Sorry.
On the ground, Milord, they indicate Lordship because of that. Lordship would say
You
that.
need not to say anything, sir, in 136. We are not inclined to entertain. Finish. Nothing more. Thank you, sir. List
I won't be able to.
List before a bench in which Brother Justice Chandulkar is brought.
Yes. My lord, can it be on Friday or something?
Can we do, sir? The learned senior, when once brother is saying, can we do?
But otherwise.
We'll take a repose with the registry. Next.
The suit is filed, Lords, on primarily 3 grounds. Lords, non-payment of rent, nuisance and damage in 2015. Lords, in 2022, a new ground is added for bona fide need. Lords, the High Court, the trial court and the first appellate court, Lord, accept that and say there is a bona fide need. Lord, may kindly have page 4 for a moment. Lord, there is a statement which is recorded, which says that it has come on record. Lord's 6th line from the top, page 4. In the oral testimony of the plaintiff, it has come on record that there are 3 rooms available on first floor, and as per submissions made by the appellants, there is a 3-storied hospital constructed by the plaintiffs themselves. But this is only a 5 by 5, 3 shops. Now their case is that they want to establish a clinic. Lord, the father is already a doctor, Lord, practicing in the city, Lord, for the past 30 years. Lord, this plea is introduced after 7 years when they know the Lord.
How much time you want, sir?
Lord,
How much time you want to vacate?
Lord, may I have it, Lord, at least till the end of this year, Lord.
End of this year. Fine. Dismiss. Undertaking within 3 weeks, 4 weeks. In areas for condition to areas. Thank you.
Yes.
26. Somebody connect. Yes, sir. Serial number 26.
Milords, I am appearing on the behalf of the petitioner, Milords.
Yes, please.
Milords, the wife and the 2 minor daughters, Milords, the petitioners are the legally wedded wife and 2 minor daughter of the respondent, Milords. Milords, their marriage was solemnized on 12th May 2011, Milords. My lords, here the issue is in respect to that the respondent husband has preferred a criminal revision 2952 of 2024 before the Allahabad.
Notice from Delhi as well as on Assam. Thank you. Yes, sir.
My lord, my predecessor in interest, the revenue entry was in his favor, my lord, the possession was continuously in his favor. These aspects have not been considered, neither by the High Court, all the three courts, my lord. I did raise this issue as paid in the review court also, my lord. The review court said that you are raising this issue for the first time here. It is completely incorrect. My lord, may kindly come to page.
Come on the merits, sir. Review.
Very well, very well, my lord.
Come on the merits of the case.
My lord, for past 50 years, my lord.
Come on the merits of the case.
My lord, the first issue itself, my lord, page 85. My lord, may kindly see the issue number 1 in paragraph 7.
If we see here, plaintiff with this Rachmalla one side and the defendant Peda Benkash and the side is Rudramalla Mutaya and Rudramalla Venkatesh.
Yes, my lord.
And both family, this is just like this. Both family given half and half, and now they want
my lord,
contest of this.
This is my
concurrently court recorded against you.
The consistent case of my lord, the consistent case of the petitioner here, my lord, that this land was, my lord, absolutely in my possession and my ownership with the title.
Sorry, sir.
Grateful, man.
I'm so grateful.
There is a delay, my lord.
Why delay, sir?
Delay, my lord, because of
More
the
than 2 days.
original order, my lord. Review order, I am in time. Both the orders have been challenged.
Allah in delay control.
Great.
You must be happy a little. Is why going from here. जी? Okay, allow कर देना, ये execution में problem है. 34. 34.
They represent
34.
the respondents. Again, a case of regularization.
The matter was listed on non-miscellaneous day, Lordship. Bunch of matters, Lordship, they are seeking the regularization.
NMD.
Lordship. Released by NMD, Lordship.
Go in August.
That's what they want, Malats. They've been working for almost 9 years now, Malats.
They are protected as of now.
We are not saying anything. We are not deciding. We are thinking, let it be in NMD after.
Yes.
They want to take a chance at appropriate place.
Absolutely, Malats.
Take it. No problem.
In 35, seeking a Passover minutes.
Passover.
Yes.
36.
Your Lordship seeking a Passover.
My lords may have it on a NMD, my lords. The pleadings are complete.
We'll go on NMD.
Great.
September no कोई date लगाना है. 37 there is a letter.
38 I am requesting for accommodation, Lord. I tried to circulate a letter, but it.
That side.
My lord, I'm appearing for other side.
Have you filed a counter affidavit?
No, my lord, I have to file, but it's a short point. My lord, Vinita Sharma has taken care of this already, and the judgment in case of Prakash versus Phulwati and Danamma, that has already been overruled. Therefore, this point is already considered. Kindly see para 8 of the impugned order, my lord.
You don't want to file counter.
My lord, I will file if your lordship say, but
No, we will not say anything, sir. If you are interested.
I will file it. I will file.
That you are not interested to file counter affidavit.
Let it be, my lord, second week of July. Third week.
September will happen. Okay.
Grateful.
Meantime, counter affidavit will file 8 weeks counter, 2 weeks remember.
Grateful. I'm.
Malas, may I seek up for a Passover, Malas? I would like to bring on record, Malas, in any way. Documents on record in any case. Malas will have to go on. Malas, may kindly pass it over, Malas. It will have to go on.
It will take time.
Malas, it will not take time. Malas, a very short issue involved in this, Malas. Very, very short issue, Malas. The only issue. Malas, may kindly. Malas, that's the only factor. Malas, it's just a very small issue, Malas, which is involving about that, Malas, date of service, Malas. My date of service is the only issue, Malas. My respectful submission is, Malas, may kindly pass it over.
Item 40. Item 40. Item 40.
Please, Your Lordship. Your Lordship, I have filed my wakalatnama.
Please, Your Lordship.
Why you don't go for mediation?
So we can explore the mediation if it is.
Mediation का कर देना.
Please, Your Lordship.
41.
Lots of seeking passover. Seeking a passover, my lord.
41.
Yes, yes, lord.
42.
Also, I'm playing for a passover.
42 passover.
All right, compliant.
43.
Lordship, the learned senior has logged in, Dr. Sophia Begum, she's logged in.
Senior is?
Logged in, Your Lordship, she's on BC.
Logged in.
May I
Dr.
be-
Sophia Begum.
May I please, Your Lordship? This is
Yes.
coming up for the instructions of the respondents, my lords. In fact, Your Lordships wanted to dispose of this matter.
Yes.
Well, as in
In
item
consonance with
43.
Sudhir Mahto versus State of Bihar.
Yes.
Yes, events of the connected judgment, my lords, applies on all fours. In fact, for the other accused, my lords, it was her house allegedly. In this case, he was found at the place allegedly. So it.
Distinct appeal. Is at present he is in custody.
Yes.
Yes, madam.
How much years, sir?
But
15 years.
15 years, inclusion of remission.
Judgment of conviction sentence. Judgment लगा हुआ है मेरा. ठीक है. ये judgment same इसी में कोई accused है. ठीक है. So and so. In criminal appeal 1051 same judgment. Arising out of the same judgment dated so and so, the present appeal has been filed. Full stop. This indeed not in dispute that the co-accused Gauri Mehto and Gauri Kumar, alias Gauri Kumar, filed criminal appeal number so and so before this court. We are appreciating the entire evidence. With the judgment dated 27th of February 25, acquitted the accused. Full stop. Learned counsel appearing on behalf of the respondent is unable to make any distinction to the findings as recorded by this court in the said case. Full stop. Considering the same and apply the both findings in the case of so and so Richard Smith and this case.
Yes.
And acquit the accused so and so. He be released from the jail. Baki will live there if he is not required in any other case. Allowed in this court. Thank you.
Grateful, madam.
44.
Your Lordship, appearing for respondent number 7, State of Tamil Nadu, Your Lordship. There's a government change in the.
Lord, I am for.
There's a government change in the state, Your Lordship. Respondent number 7,
Lord,
State of Tamil Nadu.
Tamil Nadu.
Yes, Your Lordship.
Lord,
We're seeking an adjournment on that behalf.
Court should change
Yes, Your Lordship.
because of the government change.
Government change, Your Lordship. Government change is.
For 44.2, Lordship.
I'm sorry, Your Lordship. I couldn't hear.
My Lord, in this, Lord, I am appearing for 44.2.
Let senior.
Lord, medical
Let
counsel.
girl, please.
Your Lordship,
We used to have some wit and humor in this.
Lord, Union of India and Medical Council of India is the party in this.
Yes. What she is stating. The regime is changed in the state.
apologies, Your Lordship. I couldn't.
We are not saying madam anything. We have just put certain usual
My apologies, Your Lordship.
on the request of counsel appearing on behalf of state of Tamil Nadu. List. इसको कर देना after past working days.
Lordship, if a date in July could be given? Your Lordship, could any date in July be given?
Fixing a date, not madam, July you can understand.
Lordship.
If I am there, I can understand. I am putting on myself a burden. I cannot put a burden to others.
Lord, we have completed.
Yes, senior.
We have completed the course, my Lord. The 4 years BDS
That
and
will be
and
done.
OC.
Yeah. Clear that.
Covered by your Lordship judgment 2000. Any short date.
Fixing in August. Anything else? Earliest.
Much hope.
July, 1 week only working.
Great.
Miscellaneous 1 week working.
Grateful,
In
Lord.
that week, you know this will not be heard.
Yes.
So better in August, we are fixing some date. Much of. But madam, come, this is a matter relating to an admission, nothing can be done. As much as you will make a delay, it will be a problematic.
The new
Finish
government
it at the earliest.
much of.
45. Yes, madam. Who is appearing in this? 45.
Your Lordship, counsel for the respondent is appearing through VC, Your Lordship.
G?
Counsel for the respondent is appearing.
But in this matter, my lord, I am appearing for the respondent, my lord.
Yes.
My lord, I am fighting for more than a decade, my lord, this case, my lord. High Court has allowed the writ petition and has given the clear-cut finding that the disciplinary authority has violated the provisions of law, my lord. And on that ground, my lord, CAT order was set aside, my lord.
Yeah, this case. Who is for Union of India?
Lord, on many occasions, Lord, they have sought the time from this.
Your Lordship, I am requesting for a passover in this matter on behalf of Union of India.
Please, Your Lordship. Lordship, I am for the petition, my lord. Please, Your Lordship.
Yes.
My lord, I am for the petitioner, my lord.
You are for?
I am for the petitioner, my lord.
Yes, madam.
My lord, this case actually, the petitioner was suspended on the basis of the false FIR, and later on it was found that it was false. So for 3 years he was remain in suspension, my lord. He is asking only for the regularization for the purposes of the pension, my lord. He is already retired, my lord. He is already 66-year-old, my lord. So this is the only request. High Court has already
For the pension.
for the purposes of pension only.
This is ordered, no?
My lord.
This has been directed.
Yes, my lord. The High Court has allowed, but government has again rejected that. High Court has impugned in the judgment.
Where the government rejected? Where is that?
My lord, that already within 3 months they had to give it, but they have not considered it, my lord. After hearing of the petitioner, but they have not considered, they have not even. My lord, 3 months, more than 3 months have gone. They have not considered. They have not considered him. He has already given representation, my lord.
You are for?
I'm for the petition. I'm for
petitioner Vijay Raj.
Yes, my lord.
Yes.
My lords, we don't have any instruction whether it has been rejected or not, my lords. My lords, in 1996, he has been suspended, my lords, and found that it's a false case. He has been reinstated and the absence period was regularized and he was asked to join on a duty on a particular day, my lords. Then he went into CAT and asked that due to mental harassment, I couldn't able to work in this district. Let me post it in some other district. That also has been granted by the tribunal. Even after granting that, for a period of more than 1 year, he didn't join that, my lords. However, that also has not been considered for a barrier for a promotion. He has been promoted as an inspector grade and he retired in 2017, my lords. In the meanwhile, he filed a OA in the tribunal for regularization of that period, which he has not joined as per the tribunal's order. That has been rejected because there is no valid reason why you have not joined. Then again he filed a writ petition before the Honorable High Court asking for a regularization of the same period which he was remained absent for no reasons. That has been allowed by the single bench. Upon appeal.
What do you want to do now? Please tell us.
My lords, everything has been granted, my lords. Kindly see the tribunal's order, my lords.
This period, have you treated this period as a die zone?
My lords, it has been treated as non-duty, my lord.
Non-duty. So have you regularized this period counted for the purpose?
Only
grant of pension?
For pension, it's not, my lord.
Why not, sir?
Because
until you say it's a die zone, you cannot cut out this period. You have to count it.
My lord,
have you said so?
My lord, that rejection order was not on record, my lord. Only the review rejection was there. The reason that was annexed P1, it's a review against the rejection that has been annexed.
Seek instruction and finish.
I'll do it, my lord.
You are the Union of India.
No, my lord. State.
Fighting for no reason, sir.
My lord.
It would not make any difference.
But the only concern is.
For the sake of fighting, you fight it. As usual, as state Kerala does.
State has lot of.
Otherwise, nothing is there in this case, sir. Until you pass an order of dies known of this period, you have to regularize this. And this will be counted for the purpose of pension. Or otherwise, you have to take an action that this period you remain absent. So we are holding an inquiry for this unauthorized absence. This is a misconduct. We can understand these two recourses we have taken. Otherwise, regularize, nothing third option.
We'll take it.
Okay. We have the in the counter affidavit filed by the state, nothing has been specified regarding the directions as issued by the High Court for reconsideration and regularizing the period. Police stop. It is to be noted here that in absence of passing an order in absence of an order of dice board or holding an inquiry of the absence period, it ought to be regularized. Police stop. Counsel for the state may seek instruction and file additional counter affidavit within 4 weeks. Yes, finish it, sir. No reason.
My lord, they have already regularized, but stating that it will not be considered for pensioner benefits. That is what they are saying.
For the purposes of the pension. Thank you. 47.
Appearing for NCTE.
Yes.
But I'm filed an application for infringement. It's running in the list.
For the board, petitioners will have to.
Go in NMD. 48.
Your lordships, I appear on behalf of the petitioner.
Maybe Lordship may grant leave in this matter.
Which matter?
47.
What?
Better.
No, nothing. This
2
can
days.
be heard, sir.
Very.
This can be heard, Kunal. Nothing is there in this. Much more.
Your lordships,
48.
your lordships, I appear on behalf of the petitioner in this matter.
My lord, I beg to appear for the respondent. My lord, may I seek some accommodation today? I was a little unwell, if my lord may permit.
Your lordships may fix it for final hearing in August or September, your lordships.
Grateful, my lord.
49.1, there is a letter.
I said, I requested for it.
You circulate.
Yes, madam.
Let it go after.
Sure. Let it be NMD, Miller. There's already an order.
Much obliged.
Wait, please, Your Lordship. Item 50 proceedings are complete. Lordship may fix it on an NMD in August.
Please.
In some date, my lord.
51.
50 some date, my lord, August, September.
August, September. Fixed
Deep
date,
here.
NMD.
Please.
Space में देखते हैं.
Manoj,
51.
I'm appearing for the respondent. As such, this is a consent order. As such, this is a consent order in 51.
Come on NMD, please. Make your submission. We are not going against. 51, sir.
51, my lordship.
51, I'm saying it's a
My
consent order as such.
Okay.
My lordship, the family court has not granted the divorce because there was no cruelty or decision on the part of wife. My lordship, the High Court has granted divorce only on the ground that it has been 20 years they are living separately.
Go for mediation.
Mediation, my lordship.
Better go for mediation.
No problem, my lord.
57, 52.
May I please, your lordship. Lordship, the only issue on which there was agitation in High Court was the 6 months notice period. The tenants are sitting in property for more than 40 years. At this juncture, we are ready to give them 6 months if they vacate thereafter. Rest, everything is decided in my favor.
My lords, the matter is already set for pre-Lok Adalat for tomorrow by the Supreme Court.
It can be disposed of today.
Although Mishra, Madam Mishra, Karachi, it can go, then Lok Adalat can get it done.
My
Your
lords,
lordship, I mean,
6 months you are offering.
I'm offering 6 months.
You seek instruction, madam.
For
my
tomorrow,
lords,
then I will.
we need time to file the counter too.
9 months they have taken to file counter.
My lords, we filed Wakalatnama.
4 weeks time to file the counter affidavit is allowed. Full stop. It is informed that the matter is coming in the Lok Adalat. However, the parties may seek instruction to and to apprise in the Lok Adalat regarding vacation of the premises. Full stop.
My lords, just a humble request, my lords, if the time can be extended to 6 weeks, as the main counsel just suffered a heart attack past month only.
Now 4 weeks you are here now.
My
You
lord.
can get it done.
My lord.
Lordship can give a date. I mean, tomorrow we'll appear before the Lok Adalat, but if it doesn't get settled, a date before this honorable court.
Then on the Lok Adalat you can ask Prachi. What we
As
can
your
do
lordship.
today?
As your lordship. Deeply obliged.
Yes.
Please, Lord. My Lord, sanitation workers.
Subsequent development.
My Lord.
There is also, I understand, but there is a change in dispensation. Your lordship also knows that.
We don't.
Have it in July. Have it in July.
My Lord, sanitation.
Very well.
For 5 minutes, your lordship may have to, this may not require what he's saying. My lords,
I have not said anything.
the present application has been filed by temporary employees working for 10 to 21 years.
Except this 53.1, it's a different 53.10.
Yes, because that's RSLP. Now, what has happened? That board is also that recruitment board is also now stayed struck down by the High Court. It's been considered by a lordship.
But this appears to be different matter.
I understand.
Yes, my Lord. We are sanitation workers, my
By
Lord.
one. So far as other cases are concerned, we are adjourning to the August or
My
September.
lords,
One thing, interim order to continue. Yes, sir. What do you want to say? Interim order to continue. What do you want to say?
By the law, my lord, just the thing is that they have been working for 15 to 21 years. In the subsequent development, it is covered by lordship judgment in
No,
power.
nothing doing, sir. Let it to be examined. We have understand.
My lord, I have
Section 9 has been stepped down. Now we have to look into in that context. We are aware.
Lord, just
Let
one
it be examined, sir. Now we will
one
not
request.
examine.
my lords,
One
53.10.
request, my Lord. Once your
53.
lordships- Is this, that my Lord, your lordships are now hearing, my Lord, an SLP at the instance of the board, my Lord, against the order which struck down, my Lord, section 9 validity. Let it be heard along with that, because unless and until they have power to
That
recruit.
SLP is there.
Yes, I have the order. My Lords, I have one submission, my Lords. My Lords, our case is slightly different, my Lord, if your lordship may permit me.
That would be hard altogether.
Yes, my Lord,
We are
in fact-
not saying nobody would be hurt.
I give, my Lords, we are all sanitation workers, my Lords.
My lords,
Sanitation workers.
53.10, as my lords suggest, it is a different matter, my lords. Actually, I am demoted actually. For the
Lords,
last
my Lord,
many
one second,
years, I am
Lords, if your
waiting for
lordship
this,
may
my
hear me.
lords.
At this point, demotion.
My lords,
My Lords,
your
my
lordship
Lords, only
kindly
submission, my Lord.
appreciate.
My Lord, only submission, my Lord. We are all sanitation workers, my Lords.
September में लगा देना सबको along with tag with so and so. साथ में लगा देना.
First July.
21st of July is coming. List along with so and so. The matter which is coming on 21st of July.
My Lord, slightly,
In the
one
meantime,
submission.
interim order to continue.
My Lord, we are all sanitation workers, my Lords. We have been working for last 20 years in this establishment.
Denying sir to anyone you are.
No, I agree, my Lord, but the fact is, my Lord, our case is completely different, my Lord. My Lord, we have come in, my
Detect कर देना.
Lord, we have been joined before the act came into existence.
Detect. We list separately.
Please, my lords. That may be listed end of July, my lords.
Sir, it is coming on the day on which the other case is coming. We are tagging it all. Let it be
Yeah,
there.
my lords. My lords, because it's since it.
Thank you, sir. 54.
Still the appearance.
54.
Please, Lords. Lords, here the pleadings are complete.
Will go on
Can be
NMD.
taken up for my lords. Could a date be specified
Will
or
go in September.
my lords? Very well. Very well. Public lords.
Sir, we are for this. We are
Sorry, my lords. Sorry, previous matter interim order may be continued.
interim order to continue.
Great, my lord.
Mr. Parmeshwar, this matter is 27, at 4:15 for the state of UP also. The chief is inaugurating this. All right. So it would be better on 27 means it may come on some other day thereafter. On tomorrow. It is coming. No. Tomorrow. The chief is inaugurating of that. So we'll list after. 28 is not a working. No, it's all right, sir. We did our job, sir. This is institution will go on. It's not necessary that I should do it. Any other judge will do.
taken so much pains in activating the website.
All right, we did our job, sir. You were a part of this. We did our job, sir.
Lordship, it has been operationalized. Module has been operationalized. I have filed the affidavit yesterday. My colleague is in the court with the copies of the affidavit because it has not come. 10 proposals at Central Jail Agra and 4 proposals at Lucknow have been processed.
Now the fast track you have won, which fast tracks? Meerut, Agra and Lucknow, 3.
Lordship 2. Lordship said Central Jail Agra and Lucknow as a pilot project. That has started.
All right, we'll take it.
Starts with 2.
All right, we'll take it at 2. This affidavit may be taken on. मुझे इसका वो चाहिएगा. कल वो चीफ ने रखा हुआ है इसका इनॉग्रेशन. पहली स्पीच मेरी है उसमें. मुझे देखना पड़ेगा उसे. I have to see. Please put it. This. Oh, सुनो. उनको बोलना इसमें से सब ऑर्डर शीट निकालेंगे पूरी. उसको मुझे बताएंगे. Reference. 59.
Pursuant to Lordship's order, we have made the complete payment on the last day itself, Lordship.
I have received the payment, Lord. She's, yes.
Yes.
On 22nd itself, she is appearing to VC.
Yeah, exactly.
Your Lordships have
उसका
permitted.
स्टेटमेंट आ गया क्या नीचे से रजिस्ट्रार के यहाँ से रिकॉर्ड हुआ होगा स्टेटमेंट आया रजिस्ट्रार के यहाँ से
The office reports indicates, Lordship.
kindly connect that girl.
Yes, yes.
इससे पूछना पड़ेगा ना अमाउंट इशू She knows English, no? She knows English.
No, my lords, I have asked my learned
So my
colleague.
colleague
my
was translating.
Yes.
She will translate, my lords. She only understands that.
She's asking. Rest to be. She's there. She's reading.
Please kindly connect her.
She's there. I've asked her to switch on the video, my lords. She's there, my lords. I've asked her to switch on the video.
She's here?
No,
No,
she's
she's
virtually
with
appearing,
VC,
Lord.
your lords.
She's virtually.
But I've asked my colleague to ask her to switch on the video, my lords.
நல்லா இருக்கிறீங்களா இருங்க இருங்க ஒரு வீடியோ காலு அங்க ஆபீஸ்ல பேசுறேன்
Madam, you translate. You can communicate her. She knows. You ask, please, ma'am, please. You ask whether you received the entire amount of which 10 lakhs in total.
மா இன் டோட்டல் 10 லட்ச ரூபா உங்க அக்கவுண்ட்க்கு வந்துருச்சான்னு கேக்குறாங்க ஜட்ஜ் சார்.
வந்துருச்சுங்கம்மா.
She says it has been received.
You ask to get set aside this judgment in which conviction is there.
இப்போ இந்த ஜட்ஜ்மெண்ட்
This man is there.
இந்த ஜட்ஜ்மெண்ட் வந்து அவர் கன்விக்ஷன் வாங்கியிருக்காரு இல்லம்மா, அவருக்கு அகேன்ஸ்டா வந்திருக்கு இல்லையா, அது செட் அசைட் பண்றதுக்கு உங்களுக்கு வந்து ஓகேவான்னு கேக்குறாரு ஜஸ்டிஸ். இந்த கேஸை முடிக்கிறதுக்கு ஓகேவா, ஏன்னா அவர் மேல கன்விக்ஷன் இருக்கு, இருந்தாலும் அந்த கேஸை வந்து க்ளோஸ் பண்றதுக்கு உங்களுக்கு ஓகேவான்னு கேக்குறாரு. She is saying okay.
Right. You were there at that time?
Yes, ma'am.
And then when this statement got recorded?
Yes, yes.
You were there?
Yes, ma'am.
Lordship.
We will do it. We will set aside this.
Very grateful, Lordship, for
The
indulgence.
conviction because of her
Yes, very
recording
grateful.
her consent.
Both young lives fellows will get a new direction, particularly petitioner.
Anyway, let them live their life in
Lordship.
their own way.
Plus, also one request, fellows, in the interest.
For the government, Inspector of Police, State Representative.
Mr. Sabrish was appearing. Mr. Sabrish used to appear, Lordship. Sabrish standing also used to appear.
Tamil Nadu.
But somebody was appearing up till last date, Lordship.
Yes, please.
You call.
I'll call.
Call somebody.
I'll call.
We will, my lords.
Otherwise, it will be a problem. Another problem, they will come up with that. That we have not been heard.
No, but when the Lordship had recorded the statement also on the day of that hearing, they were present.
Yes, sir, we are aware of what,
Lordship.
everything,
Lordship.
but something must come.
Very well, Lordship can, will just.
Please call somebody.
Right.
Somebody, you call.
We'll do.
60.
Well, it's really led by the learned attorney, but let's keep it after, Lordships are sitting after lunch.
Sir,
Well,
I'm
let's
appearing.
Mr. Luthra is appearing through VC.
Not
Well,
in
let's
fact,
keep it after lunch.
whatever my learned
It's
friend
just
says,
not
because now whatever my friend says. No?
Well, we have affidavit which we have filed, but which is not on also to be brought on record.
May I just say this, Lord, we agree with what the attorney says. It's just that there's one page note which my learned colleague will hand over. Lord,
There's an
we agree
affidavit.
with everything. I know.
There's
The
also,
affidavit
sir,
we
there is
seen.
also an affidavit which has
Yes,
been
I've
filed.
read the affidavit. We agree with your affidavit. A lot of work has been done, but the union has limitations, and that's why the attorney's suggestions will be very useful. On the last occasion, the solicitor may.
The note and the affidavit.
Yes. We are agreeing with that.
We will sit after lunch and we'll see and we'll pass certain direction.
The learned attorney.
Lord, I've given you a lordship a one-page note, and I mentioned there also what the union has sought, which is in
After lunch, sir. We are coming after lunch.
Yes, for 2 p.m. Grateful.
2:15. 2:15 we are coming.
Grateful.
2:15 we are.
Deeply.
3-4 cases. Last में जाएगा ना. We are coming. Coming back.